Welcome back to the video lecture on East Asian State Leadership in International Law. This time, we are going to talk about diplomatic privilege and immunity in terms of defining a contact point between the principle of reciprocity and protection of nationals. In April 2022, the wife of the Belgian ambassador was charged for hitting the back of the shop assistant's head at the clothes store in downtown Seoul and slapping another assistant's face while trying to pull her away. Although this assault scene went viral and causing national uproar, the party insists on privilege and immunity applied to diplomats and their family members, and the police decide they lacked the power to send the file to prosecution. The Belgian government eventually took measures to return the said ambassador after another incident in which the ambassador's wife has assaulted the cleaner 3 months later, the previous incident. More cases have been reported through media. The US diplomat who refused to follow the police order but leaving the scene without taking any action after crossing into the back of the taxi in downtown Seoul in November 2022, and the husband of the Dutch consul who hit a passerby while parking. This issue brings us to the question is that, for example, should diplomatic privilege and immunity which are abused by the envoys as a means of shield continue? And or should such a privilege and immunity be applied indiscriminately and without criticism when every citizen can become the victims of the damage? These privileges and immunities afford the diplomatic envoys, which are far from the current national legal sentiments, have long formed and been recognized by the customary international law and relevant treaty. For example, the Vienna Convention on Diplomatic Relations stipulates privilege and immunity and the measure for residing diplomatic envoys. The convention officially entered into force in 1964 and is currently recognized as a universal treaty in which 193 countries, including South and North Korea, are joined as parties. In practice, the diplomatic privilege and immunity is effective based on the reciprocity. In general, upon a victim's application, they can request the waiver of diplomatic privilege and immunity to the diplomatic missions. In most cases, the peaceful measures are taken in fear of worsening public outrage in diplomatic relations in the host states. The perpetrating party country summons the diplomat and take internal measures to penalize the personnel without making the diplomatic envoy to waiver of privilege and immunity or subject to civil and criminal jurisdiction of the affected state. In the end, the diplomatic authority do not find the need to raise any issues regarding diplomatic privilege and immunity when they can become the perpetrating party at one time and affected party at another. Despite recognizing the blind spot in the system and protecting the rights of the affected nationals, which country should actually take the lead in initiating improvements is a whole different question posed. Instead of relying on the goodwill of the embassy and the state to resolve the situation on a case-by-case basis unofficially, as it is now, the need for the state and government to put in place a systematic legal relief for their nationals is raised. It is extremely challenging to change the practice of the diplomatic privilege and immunity deeply rooted in the basic principles and customary international law and universal treaties, and the validity for the change is also questioned. Nevertheless, the right of the victims placed in the blind spot of the old practices and the right of the host country, which are reflected in the spirit of the time, must be taken into consideration while implementing international laws such as Vienna Convention on the diplomatic privilege and immunities. In general, even those subject to diplomatic privilege or immunity may be subject to civil damages in a case of the assault that occurred outside their official duties. However, in this case, even if the victims win the case, often face difficulties the receiving compensation or the court award because more often than not there is no property to be seized in Korea, and effectuating the court decision in the diplomat's jurisdiction is costly and ineffective. While recognizing the whole and legal protection against Korean nationals being affected by illegal activities of residing diplomat, it is not easy to propose the alternative as to the problem raised. Therefore, it is also suggests the government should include the affected victims as a subject to be supported or compensated by the state at a national level, and that the expenses incurred should be resolved through diplomatic channels with the relevant state in the future. According to statistics regarding privilege and immunity submitted to the National Assembly by the Ministry of Foreign Affairs Diplomatic Mission Office, there have been no cases in which diplomatic envoys in Korea have been punished by waiving jurisdiction in the last 10 years. And over the last 5 years, a total of the 69 cases, most of which are traffic accidents, petty thefts, and so on and so forth, and no account of violent crimes have been reported. The latest reported case of the Korean diplomat committing a crime overseas is a sexual harassment case by a diplomat at the Korean embassy in New Zealand, which received wide media attention. The Ministry of Foreign Affairs reportedly agreed on a settlement last year after 3 years since the incident took place. The case, which was resolved by a mutual agreement through a private arbitration under the New Zealand labor law, was initiated by the Prime Minister of New Zealand, requesting resolve the case with then President Moon Jae-in and the Blue House. Nevertheless, the possibility of filing civil and criminal suits on a private level between the private parties still remains open, as the agreement was made between the employer, Ministry of Foreign Affairs, and the victim. Therefore, there seems to be no significant difference in operation and implementation of the diplomatic privilege and immunity related to diplomatic envoy stations in Korea or Korean diplomat operating in foreign countries. In relation to this, the method to provide compensation and aid for the said victims in Korea is first, including them as a person subject to support under the current crime and victim protection law. Currently, only those who are killed or seriously injured according to a specific crime may be subjected, but there may be a way to include those who are affected by diplomatic privilege and immunity. The second, by means of enacting a special act, such as a special act for the protection of victims of illegal activities by foreign envoys, tentatively subject to change. If some amount of damage is supported or compensated from the state budget, or if a victim claims civil damages against perpetrator, for example, individual diplomat personally, there may be a plan to aid the cost or the procedure, for example, improvements in litigation relief. Despite its historical and practical importance, the Vienna Convention on Diplomatic Relations and its basic principles have resulted in the protection of the rights and interests of the general public of the receiving state being blindsided by the abuse of the diplomatic privilege and immunity in consistence with the spirit of the time. It is necessary to consider establishing an institutional mechanism that can reflect the spirit of the times, respecting right of the victims and protecting the reasonable exercise of the diplomatic rights of the host state, and hope that the Korea exercise its initiative in implementing these concerns. Lastly, this lecture writes in hopeful anticipation of innovative diplomacy, which can contribute to the formation of a new paradigm of the international law in accepting the international system by proposing a resolution that encompasses abuse of the diplomatic privileges and voluntary waiver of the immunity and call for compensation for victims. Thank you very much for your very kind attention.